Welcome to Nyay Patsala, where today we embark on a journey to decode the genetic blueprint of DNA profiling within the realm of criminal law. We all know that DNA technology, as a part of forensic science and scientific discipline, not only provides guidance to investigation but also supplies the court accurate information about the tendenting features of the identification of criminals. After the amendment of the Criminal Procedure Code by the insertion of Section 53A CRPC, DNA profiling has now become a part of the statutory scheme. We have already discussed Section 53A CRPC in a separate video. Kindly look into it because it relates to the examination of a person accused of rape by a medical practitioner. Similarly, under Section 164A, which was also inserted by the Act of 2005, for medical examination of the victim of rape, the medical practitioner has to note the description of the material taken from the person of the woman for DNA profiling, and that is a mandatory requirement. We must also note that the evidence of experts which is given during trial is admissible in evidence in terms of Section 45 of the Evidence Act 1872. So let us understand what is DNA. DNA means deoxyribonucleic acid, and in short we refer to as DNA. And where it is found? It is found in the chromosomes of the cells of living beings, and it is considered as the blueprint of an individual. And DNA is the basic genetic material in all human body cell. But we must remember that DNA is not contained in the red blood corpuscles or RBC. It is present in white blood corpuscles or WBC. And from the point of view of criminal law, we must remember that DNA carries the genetic code and it determines the human character, behavior and body characteristics. And DNA profiles are encrypted sets of numbers which reflect a person's DNA makeup, and which in forensics or in criminal law we use to identify the human beings. In scientific parlance, DNA is a complex molecule which has a double helix structure which can be compared with a two-step rope ladder. But from the criminal law point of view, DNA is important because DNA decides the characteristics of the person, such as the color of the skin, type of hair, nails, and so on. And as a lawyer, we use the genetic fingerprinting for identification of an individual, which is done like in the traditional method of identifying fingerprints of offenders. And in law, we consider that the identification of DNA is 100% precise. And if the DNA fingerprint of a person matches with that of a sample, it means that the sample has come from that person only. The chances or the probability of two persons except identical twins having the same DNA fingerprint is around 1 in 30 billion of the world population. So let us examine some of the decisions of the Honorable Supreme Court from which it is clear that DNA report deserves to be accepted. Of course, unless it is absolutely dented, and for non-acceptance of the same, as a counsel or for the defense, it has to be established that there had been no quality control or quality assurance. But if the sampling is proper and if there is no evidence as to tampering of samples, the DNA test report is to be accepted. The first case which I would like to analyze is Mukesh versus State and City of Delhi, that is reported in 2017 6 SCC, and kindly refer to paragraph number 211 and 212. Relying on the judgment of a foreign court in the judgment of Mukesh, the Honorable Supreme Court has discussed the nature and characteristics of DNA and how it has been explained by Lord Justice Phillips in the case of R versus Donne. I have given the citation in the screen. You may kindly take note of it. The Honorable Supreme Court of India had the occasion to consider various aspects of DNA profiling and DNA reports. One of the celebrated cases of Justice K.T. Thomas in Kamti Devi versus Posiram, reported in 2001, 5 SCC 311, para 10. Kindly look into these two judgments in respect of DNA profiling. But at this stage, we must remember that under Section 112 of the Evidence Act, which was enacted at a time when the modern scientific advancements with DNA as well as RNA tests were not even in contemplation of the legislature. So let us look into the text of Section 112 of the Evidence Act 1872. Section 112 of the Evidence Act starts with the heading, birth during marriage, conclusive proof of legitimacy. And it starts by stating, kindly listen carefully, I have put it in the screen, you may take note of it, pause here and also look into your barrack. Section 112 says, the fact that any person was born during the continuation of a valid marriage between his mother and any man, or within 280 days after his dissolution, the mother remained unmarried, it shall be a conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other any time when he could have been begotten. In this respect, let us look into one of the judgment of the Honorable Supreme Court, wherein a DNA test was considered over presumption of conclusive proof under Section 112 of the Evidence Act 1872. It is, you may take note of the name of the parties. It is Nandilal Vasudev Badvek versus Lata Nandalal Badvek, reported in 2014, 2 SCC 576, and the relevant paragraphs are paragraph 19 and 20. In that case, the appellant, who was the father of the child born to his wife, questioned the paternity of the child on the ground that she did not stay with him for the last 2 years. Then the court directed for DNA tests, and the DNA result opined that the appellant was not only the biological father of the child, but the court also had occasion to consider Section 112 of the Evidence Act, which raises a presumption that birth during marriage is conclusive proof of legitimacy. But in this case, the court relied on the DNA test, holding the DNA test to be scientifically accurate. Take note that although Section 112 of the Evidence Act raises a presumption of conclusive proof on satisfaction of conditions enumerated therein, but the same is always rebuttable. And when there is a conflict between a conclusive proof envisaged under law and a proof based on scientific advancement accepted by the world community to be correct, the latter must always prevail over the former. Also take note that there is no difference between conclusive evidence and conclusive proof, and the aim of both being to give finality to the establishment of the existence of a fact from the proof of another. In that regard, you may look into the judgment of Somonti versus State of Punjab, reported in AI 1963, Supreme Court 151. Section 112 of the Evidence Act is a very important section. You will read into the barrack, look into word by word, and also look into the judgment of Narayan Dutt Tiwari versus Ruhit Sekhar, 2012, 12 SCC 554. We must remember that Section 112 of the Evidence Act is intended to safeguard the interests of the child. And how it is safeguarded? By securing his or her legitimacy and not to paternity. But a child has also the right to know the truth of his or her origin. And the right of a child to know the biological roots can be enforced through reliable scientific tests. And if the interest of the child is best subserved by establishing paternity of someone who is not the husband of his mother, the court should not serve that consideration altogether. In this regard, Indian law casts an obligation upon a biological father to maintain his child and does not disregard rights of an illegitimate child to maintenance. In the case of Gautam Kundu versus State of West Bengal, reported in 1993, 3 SCC 418, the Supreme Court had advised against conduct of scientific tests of the nature of giving blood sample for the purpose of DNA testing in a routine manner. The court said that in a routine manner, don't take blood samples for the purpose of DNA testing. But it did not altogether ban their conduct upon third party. Likewise, the Honorable Supreme Court in the case of Sharda versus Dharampal, reported in 2003, 4 SCC 493, and Bhavani Prasad Jena versus Odisha State Commission for Women, reported in 2010, 8 SCC 633, has held that there is no violation of the right to life. Listen carefully. It says that there is no violation of the right to life or privacy of a person in directing a DNA test to be undergone by the person, and to undergo such a test is not an invasion of his right to life under Article 21 of the Constitution. In India, a matrimonial court has the power to order a person to undergo medical tests. Remember it. If despite an order passed by the court, a person refused to submit himself to such medical examination, then what will be the effect? In that case, a strong case for drawing an adverse inference would be made out under Section 114 of the Evidence Act, which enables a court to draw an adverse inference if the party does not produce the relevant evidence in his power or possession. In Bhavani Prasad Jena's case, which was reported in 2008 SCC 63, it affirms the power of the court to direct a DNA test. Of course, it is cautious that the said power should be exercised after weighing all pros and cons and satisfying the test of imminent need. In this case, the principles of test of imminent need was formulated for such an order to be fulfilled. So, the presumption of legitimacy of a child born during the substitution of a lawful wedlock, as I have already stated, is provided in Section 112 of the Evidence Act. And the main purpose of Section 112 of the Evidence Act is directed towards safeguarding the interests of the child and protected him from being bastardized in the event that his paternity is in question. However, that is not the issue in most of the cases which were decided by the Honorable Supreme Court. In some of the cases of the Honorable Supreme Court, it is also seen that the person who was resisting parenthood at the cost of bastardizing the child, the Supreme Court has held that it does not apply where the child on attaining adulthood moves the court to determine his parentage. The question of protective jurisdiction of the court or applicability of Section 112 of the Evidence Act then does not arise. Now let us examine some of the cases where the Honorable Supreme Court has relied on DNA examination. In Santosh Kumar Singh versus State, reported in 2010 9 SCC 747, in this case, a young girl who was raped and murdered, the DNA reports were relied by the High Court, and subsequently it was approved by the Supreme Court, and it observed that the trial court was not justifying in rejecting the DNA report, as nothing adverse could be pointed out against the two experts who had submitted it. And accordingly, the court accepted the DNA report as being scientifically accurate and an exact science as held by the Supreme Court in the earlier case of Kamti Devi versus Posiram, reported in 2001 5 SCC 311. The next case is Inspector of Police versus John David, reported in 2011 5 SCC 509, and the relevant paragraph is 60. Here, a young boy who was studying in MBBS course was brutally murdered by his senior. The torso and the head were recovered from different places, which were identified by the father of the deceased. And to confirm the said facts, the blood samples of the father and mother of the deceased were taken, and which were subjected to DNA tests. And from the DNA, the identification of the deceased was proof. In Kishan Kumar Malik versus State of Haryana, reported in 2011 7 SCC 130, paragraph number 44. In this case, it was a case of gang rape, and the prosecution did not conduct the DNA tests or analysis and matching of semen of the appellant accused with that found on the undergarments of the prosecutrix. The Supreme Court held that after the incorporation of Section 53A in CRPC, it has now become necessary for the prosecution to go in for DNA test in such type of cases, and we have already discussed it in detail in our video on Section 53A and 164A CRPC. Kindly look into it. The next case is Surendra Kohli versus State of UP, reported in 2011 4 SCC 80, paragraph number 12. In this case, the appellant was a serial killer, and he was awarded death sentence, which was confirmed by the High Court. And while confirming the death sentence, the court relied on the result of the DNA test conducted on the part of the body of the deceased girl. In the case of Mohammad Azbal Amir Kasab, the Bombay case versus State of Maharashtra, reported in 2012 9 SCC 1, paragraph number 333. In that case, we all know that the accused was awarded death sentence on charges of killing large number of innocent persons on 26/11/2008 at Bombay. And in this case, it was found that the accused with others had come from Pakistan using a boat called Kuber, and several articles were recovered from the Kuber. The stains of sweat, saliva, and other body secretions on those articles were subjected to DNA test, and the DNA test matched with several accused. The next case is Sandeep versus State of UP, reported in 2012 6 SCC 107, paragraph 67. In this case, the facts related to the murder of a pregnant paramour or girlfriend, an unborn child of the accused, and the DNA report confirmed that the appellant was the father of the unborn child. Similarly, in the case of Rajkumar versus State of MP, reported in 2014 5 SCC 353, paragraph number 8. In this case also, the court was dealing with a case of rape and murder of a 14-year-old girl, and the DNA report established the presence of semen of the appellant in the vaginal swab of the prosecutrix, and the conviction was recorded relying on the DNA report. The next case is Sunil versus State of Madhya Pradesh, reported in 2017 4 SCC 393. In this case, a positive result of the DNA test constitute cleansing evidence against the accused. But however, if the result of the test is in the negative, that is favoring the accused, or if DNA profiling had not been done in a given case, the weight of the other materials and evidence on record will still have to be considered. It is not that DNA has become negative so that the entire benefit will go to the accused. The other statements of the witness and other materials on the record has to be considered. And in the celebrated case of Selvi versus State of Karnataka, which we have referred in many of our videos, reported in 2010 7 SCC 263, the Supreme Court upheld the authority of the civil court to order a medical examination in exercise of the inherent power vested in it by Section 151 CPC. But though it was observed by the Supreme Court that the same reasoning cannot be applied in the criminal context. In this regard, kindly look at para 175 of the Selvi's judgment. However, in para 203, it was held by the Supreme Court that compel extraction of blood sample in the course of a medical examination does not amount to conduct that shocks the conscience, and the use of force as may be reasonably mandated by law, and hence it meets the threshold of procedure established by law. This was the observation of the Supreme Court in that Selvi's case. The next case is of Ravi versus State of Maharashtra reported in 2019 9 SCC page 622. In this case, the evidence of the prosecution was sought to be impeached by the defense on the premise that the method of DNA analysis, there are two methods of analysis of DNA analysis. One is YSTR, followed in that case, was unreliable. And a suggestion was made that the said method does not accurately identify the accused as the perpetrator, and unlike other methods, say autosomal STR analysis, it cannot distinguish between male members in the same lineage. But the important point observed by the Supreme Court in paragraph number 36 is that the globally acknowledged medical literature, coupled with the statement of the prosecuting witnesses, who was the Assistant Director of Forensic Science Laboratory, the Supreme Court observed that it leaves nothing more able that in cases of sexual assault, and the DNA of the victim and the perpetrator are often mixed. So traditional DNA analysis like autosomal STR are not possible in such cases. So YSTR method provides a unique way of isolating only the male DNA by comparing the Y chromosome, which is found only in males. Today we have discussed the importance of DNA profiling in case of paternity suit in relation to section 112 of the Evidence Act, as well as how the Supreme Court has applied the DNA test in different criminal cases. So we hope this session on DNA profiling has provided our viewers with valuable insights into this fascinating world of genetics and forensic science. And we must understand the significance of DNA profiling in solving crimes and establishing identity, because this is crucial in today's society. And lastly, we encourage you to stay connected with us for more informative sessions like this. And kindly ensure that you don't miss out on our upcoming content. Please consider subscribing to our channel, and your support is essential in helping us continue to educate and engage with you on important topics like DNA profiling. Thank you for being a part of Nyaya Pathshala, and we look forward to sharing more knowledge with you in future. Subscribe now and stay tuned.